This conference will now be recorded.
Okay, so welcome everybody to tonight's topic. We're going to talk about solutions to real estate challenges, and we're very fortunate to have with us tonight Marty Kiar. For those of you who don't know me, I am a board certified elder law attorney, reaching my 30th year in practice. I have a very broad elder law practice, which means I work with people of all ages at all stages of the aging process. Marty, would you unmute your microphone and say hello to everybody?
Oh, well, hello, everybody. It is so good to see you all today. Thank you very much, Stephanie, for having me on. I have to tell you, I love being our Broward County property appraiser, and I feel so fortunate that you all allow me to do this. And I just wanted to let you know, being the property appraiser is the greatest job on the face of the earth because you get to interact with everybody in the county, and the nature of the job lets you help people. And I'm so excited to share with you some of the ways our office can help you and your clients today. So thank you so much, Stephanie. The last thing I want to add is I appreciate you having me on, because there's so much we can do, and sometimes the difficulty is reaching everybody. But when good people and like yourself invite me to come on and talk, it just gives me an opportunity to help that many more people. So thank you very, very much.
You're welcome, Marty. And Mila, are you with us now?
Yes, I'm here. Thank you, Stephanie, and thank you, Marty.
Okay, wonderful. A couple of goals for tonight's webinar. The first goal and topic of the evening is we're going to talk about how to solve some of the challenges that occur when a homeowner becomes incapacitated. That could be physically incapacitated, cognitively, or both. We're going to talk about solutions to passing ownership of the home on death, and we're going to talk about how to protect the home when the homeowner needs long-term care services. Our second goal for tonight is to talk about the pros and cons of different ways we can hold title to real estate, because there's not just one, and they all have different results. Our third goal is to talk about how different types of deeds can affect the outcome of ownership, both during life as well as at the demise of the owner. And our fourth goal for this evening is to talk about a very hot topic that has really risen to the surface since the beginning of COVID, and that is the scams and fraud that's going on now, especially with real estate. So we're very fortunate to have Marty with us to talk about what can you do to avoid becoming a victim and protect your home. So our first topic is, what do we do when somebody we know, it could be our family member, a neighbor, somebody at our church or synagogue, is incapacitated, and there's an issue with needing to sell the home. So I'm going to share a real life case with you that occurred during the first year of COVID. My client was the adult child of a Broward County homeowner. She had her homestead here, but she had become cognitively incapacitated. So during COVID, the son took his mother to live with him in Georgia and to take care of her. Now, unfortunately, when she was competent, she did not sign a durable power of attorney giving this child permission to make medical and or healthcare decisions for her. So when he brought her to Georgia, he had to initiate what is called a guardianship proceeding so that he could be recognized as her legal decision maker. Now, the home was here in Florida, but she was physically in Georgia, and the son was also in Georgia as the guardian. So the question became, what could he do? How could he sell the Florida home? Because his ultimate goal was to be able to use those proceeds and take care of his mother for the rest of her life. So we explored, could we avoid a guardianship? Unfortunately, the answer was no, we couldn't, because she had lost the ability to be aware and comprehend. However, because he started the guardianship in Georgia, we were able to have the Broward County Probate Division recognize his authority so that he could go forward with the real estate transaction. And then once the real estate was sold, we showed proof of that to the Florida court, and the judge closed down the Florida guardianship because there was no longer a need to continue it. But the question becomes for all of you tonight, can a guardianship be avoided? And if so, how do we do that? And when do we do that? So a guardianship, which is a court supervised proceeding for people that can no longer make their own decisions, can absolutely be avoided. But it means we have to plan in advance. It means that when we're still able to make decisions and be able to communicate and reason, we need to sign a durable power of attorney, naming somebody that we trust who is responsible to handle our financial affairs if and when the time comes that we can no longer do that for ourselves. Now, it's very important to also think about naming an alternate financial decision maker. We don't have a crystal ball to look into, so there's no way to know if the first person that we name is going to be healthy and able to make those decisions when the need arises. So we always want to have that backup plan. You can name multiple agents in your durable power of attorney, but if you're going to name several people to work together, it's very important to make sure that they're good communicators, that everybody can be on the same page, put aside their personality differences, and work to make the best decisions for the person that is incapacitated. Now, here in Florida, we had a major change in our durable power of attorney law in 2011. Now, that doesn't mean that any powers of attorney signed before then are no longer valid. They are. However, under the new law, any durable powers of attorney signed after October 2011 are required to have some very important things in the document. And here's what they have to have. There are what we refer to as superpowers. We call these high levels of financial decisions, things like the ability to sell real estate, the ability to create a trust or change a trust or make gifts to other people while we're incapacitated. Those types of financial decisions have to be spelled out, and you have to initial next to those paragraphs to indicate that you are either giving permission or you're not giving permission for the person you name to make those types of choices for you. If that is absent from the document, it is not going to be valid. It's not going to be honored when it needs to be. So that's very important. Now, what else do you need in order to have a power of attorney? Well, you need to understand what you're doing. You need to be aware of who your family members are, where do you live, what's the date, and what are your income and your assets, because that shows awareness, that shows comprehension. So even if people are at the beginning stage, let's say, of cognitive impairment, maybe they were just diagnosed by the doctor and they're a little forgetful, that does not mean that they've lost the ability to be able to sign a durable power of attorney. But what it does mean is that it's important to get this done as soon as possible. With cognitive diseases, we never know how the process is going to go. We don't know if it's going to progress slow or if it will progress fast. So it's very important to have the durable power of attorney in place while the person is still able to understand what they're doing and they're able to make the choices of who they would like to make their financial decisions for them. Remember, this is a document that only works while we're alive. So once we pass, the authority under the durable power of attorney stops. Now, show of hands, how many of you think that this type of document, no matter who writes it, is always going to be the same? Or that you can just go on the internet, let's say go to LegalZoom and download a power of attorney? Well, generally speaking, most people think that is the case, but they really aren't. So I have seen documents that people have downloaded off the internet, off of LegalZoom, and they really are not state specific. They're very misleading to the public. And unfortunately, if you rely on something off the internet and then you are no longer competent, we've lost the opportunity to fix that document. So my first recommendation of the evening is do it right from the very beginning. We don't always get the second chance to correct what we've done. Now, what's a guardianship? Let's say, like in this situation, the person was advanced in their cognitive disease process. They had no durable power of attorney. What is the option that families have? Well, the option that's left is what we call guardianship. In a lot of the Northeast states and some states out west, they call it conservatorship. It means that somebody is appointed by a court to be responsible for making decisions for the person who's incapacitated. And guardianship can cover both medical decision making as well as financial decision making. Here in Florida, our process usually takes anywhere from 4 to 6 weeks from filing the papers to having the hearing to actually having the guardian appointed and the court order signed. So you can see that this is a process that's going to take a while. It's not going to happen overnight. And again, it's one of the reasons why we encourage people to put this document in place sooner rather than later. And there's actually no magic age. You know, sometimes people say, well, when I'm retired, when I'm 60 or 65, I'm going to take care of that. There really is no magic age. It's best to do this as soon as even when our young adults turn 18, because in Florida, 18 is the age of majority. And at 18, although we may be paying bills for our adult children, paying their insurance, sending them to college, we can no longer make medical or financial decisions for them. And many times this comes as a surprise for parents here, but it's true. So getting this document in place sooner rather than later is really important. Now, one of the exceptions to the time frame for obtaining guardianship is if we have an emergency situation. And an emergency in the eyes of the judges is either where somebody's health and well-being is being immediately jeopardized, or somebody is being financially exploited. And we actually have to have witnesses willing to come forward and testify to prove that there is an actual emergency. If there's an emergency, then we can get into court right away. Otherwise, we're looking at 4 weeks to get to the hearing and another 2 weeks to actually have the guardian appointed after the hearing. Now, one of the reasons we really want to think about avoiding guardianship and planning ahead is because there is a loss of privacy. You know, today and since 2012, Florida's courts are based on an electronic system. So anybody can sit at their home computer, go to the Broward County Court website, type in somebody's name, and they will be able to have some limited access to see what documents have been filed. So a guardianship is a public record that is accessible. So one of the benefits of doing the durable power of attorney is maintaining privacy in our lives, keeping our lives confidential. So our neighbors or other people we don't even know will not know what's happening. Another reason to avoid guardianship is it can be expensive. And the reason it's expensive is that the court proceeding doesn't stop when the guardian is appointed. The proceeding is going to continue for the rest of the incapacitated person's life, and that could be many years depending on what the incapacity is. In Florida, a guardian has to continue to be represented by an attorney to guide them, make sure that they meet all the court requirements, and that they're informed of how to take care of this person, how to manage their assets. So those are the really important reasons why we want to do the planning ahead of time and avoid guardianship. The next challenge that we're going to talk about this evening is probate, and how does probate affect real estate that we own? So show of hands, how many people have heard if you have a last will and testament, then your assets don't go through probate? A lot of people tend to think that that is true, and it's just the opposite. That's a myth. So if we own an asset in our name alone, meaning there's no joint owner, whether it's our spouse, our significant other, an adult child. So if there's no joint owner, in order to get to the ultimate beneficiary, it has to go through the court process called probate. Or if we didn't designate a beneficiary on the asset, for example, with a bank account or certain investments, you can indicate who you want a beneficiary to be. You can say transfer on death to this person or pay on death to this person. Then it will not go through probate. But if it's just in our name alone, the will instruct the judge who's going to be the personal representative, who is going to inherit. So that's the rule of thumb that we see. Now, if you've ever heard people say, oh, you don't want to go through probate, it's awful, it's going to take years, things are going to get tied up in the court, that's a rumor that is not accurate. And here's why it's not accurate. Most probates in Florida are going to take between 3 to 4 months to complete, on average. When you hear a probate taking 2 or more years, it either means that there is a contested case going on, perhaps the will is being contested, there may be an adversary proceeding between beneficiaries, or the person who died had a very large estate and there are federal estate taxes that need to be paid to IRS. So the probate cannot be closed until IRS receives the estate tax return, approves it, and receives any tax that is due. So that is not the average probate we see. Now, what's the benefit to the home going through the probate? Well, in Florida, we have this great constitutional homestead protection that says the home is protected from claims of creditors. So the surviving spouse or the children that are going to inherit the home have a place that's a safe haven, that they know is not going to be taken away from them. Now, the 2 exceptions to the homestead protection is if we owe a mortgage, that mortgage lender has priority, or if, let's say, we had work done on our home, we had a deck built, we did not pay the contractor, and the contractor files a mechanics lien on the property, that is the second type of creditor that we don't get the protection from. But any other creditor, the home is protected. So the benefit of having the home go through the probate proceeding is that after we publish a notice in the local newspaper and 3 months goes by, if creditors have not filed or they file late, their claim will not be honored and the home will be protected. So if you're making a will, you're probably asking yourself, well, who can I leave my home to? Well, under Florida law, you can leave it to your spouse. If you have a minor age child under 18, you can leave it to the child. But only if there is no minor child can you choose to leave it to a different beneficiary. And if you're married, you are going to need to have your spouse agree to that because the spouse has priority. So the next question people usually ask is, well, if I want to avoid probate, how do I do it? And we've already mentioned you can name a joint owner. However, the downside of naming a joint owner is that if that joint owner is, let's say, not a spouse and they have a financial hardship, let's say they have credit card debt, or let's say they're going through a divorce, or they had a business and the business failed and they're going through bankruptcy. You have to be very careful because it's not their homestead unless they've lived there. So having joint ownership is not necessarily the most protective way unless the joint owner is your spouse. So one of the other options to consider to avoid probate is called the revocable trust agreement. And this has many benefits. Number one, it saves time because the assets are not going through probate. It's also a private document, so it does not get filed with the court. It doesn't get recorded anywhere. So it acts as a management system, both while we're alive and after we pass. So the trustee will administer and handle the assets that are in the name of the trust. Nobody else knows what's going on except for the beneficiaries. And sometimes it depends on the situation. We might be able to administer the trust in about the same time that a probate takes. However, you always want to weigh the pros and cons. And one of the cons is that in our law, there is no protection from creditors by putting your assets in the trust. And the reason is this is a revocable trust, meaning during our lifetime, we can change it, we can do anything we want because we created it, so we have that ability. So because we have that control, the law looks through the trust to see us. And so if we have creditors, this is not necessarily the answer. If you're going to consider a revocable trust, there's two important things to understand. Number one is the creation of the trust as a legal document. And after that, you have to take step two, which is putting the assets into the name of the trust. So how do you do that? Well, with real estate, we would create a deed. And Mila is going to talk in a little while about different types of deeds. And you would stay the owner, but the trust would also have partial ownership of the home. And in that way, we maintain the homestead tax exemption. But we have to be careful because this is not always the right thing to do. If there's a mortgage, you have to check with your mortgage lender to make sure that putting the ownership of the home in the revocable trust isn't going to cause the loan to become due and payable. And if we're married and we have a spouse that is not competent, we may not be able to transfer ownership of the home into the trust. So we may have to wait. Everybody's situation is different, and so everybody's situation needs to be tailored to meet their individual needs and goals. Now, the third type of challenge we see fairly often is when the homeowner is aging and perhaps they need long-term care. They cannot safely live at home. They might need a home health aide, or their illness and their needs may be very advanced, and they may need skilled nursing care that cannot be provided at home. So sometimes people need to explore different ways to qualify and financially pay for their long-term care. So we may look to see benefits that are available through the Veterans Administration, as well as through the Medicaid agency in Florida. Now, to qualify for both programs, they're going to have financial requirements. For Medicaid, the person who needs the Medicaid, whether they're single or married, is going to be limited to having in their name no more than countable resources of $2,000. So what does that include? That includes bank accounts, checking, savings, money market, certificates of deposit. It will include investments, stocks, bonds, mutual funds. And if the person who needs Medicaid is married and the spouse is healthy, they don't need long-term care, then they can keep in their name up to $137,400 of countable resources. There is also in Florida a monthly income limit for the person applying for Medicaid. So Medicaid's going to look at Social Security retirement, any pension, as well as distributions from retirement plans like IRAs and 401ks. If the person applying has gross income over this level, then we need to do some more planning in order to qualify them. But there is no income limit for the spouse. What you have to be aware of, and if you walk away with anything from tonight's webinar, is to be aware and be careful that Medicaid has a 5-year look back for gifts, for transfers of assets, and that includes the home. So we have to be very careful not to jeopardize the homeowner from qualifying for Medicaid assistance or even assistance from the Veterans Administration. So in protecting the home, it's important to know that as part of our state constitution, we protect the home. We call it an exempt resource when somebody needs to qualify for Medicaid, as long as the home equity value is no greater than $636,000. Now, that's the equity level set for this calendar year. It'll go up next year as well. So how do we determine equity value? Well, we take the fair market value and we reduce it by any mortgage. And as long as the equity value is less than $636,000, the home is exempt. So if you hear somebody say, oh no, you have to take the home out of your name, you should sign a deed, give it over to your child, that's actually going to cause a problem. That will create disqualification for Medicaid. The home by itself is protected simply by saying, I intend to return home, or if a spouse is going to continue to live there, that's a basis for the home not being counted. Or even if the homeowner has an adult child with a disability living at home, that's another basis for the home being protected. So it's protected in various ways. Number one, it won't be counted for purposes of qualifying for Medicaid. Number two, when the homeowner receiving Medicaid passes away, there will not be a Medicaid lien imposed against the home. So this is a really powerful and valuable tool to use when living in Florida. So what about after Medicaid approval? What if the homeowner is now living in a skilled nursing facility and the family just can't afford the upkeep of the home, the cost of the homeowner's insurance, the real estate taxes, perhaps there's monthly or quarterly maintenance fees that are due, and of course the utilities. What are the options? Well, there's two options. Number one, there is the possibility of renting on a short-term basis that will not interfere with Medicaid eligibility, or the other option is to sell the home. Now, if the home is sold, we are taking it from its protected status as an exempt resource, and now the sale proceeds are countable. So in order to prevent the homeowner from having more than $2,000 of resources, we have to take steps to protect the proceeds. And we can do this in one of two ways. If the homeowner is under age 65, then we can create a special needs trust and put the proceeds in it. The government will be told that the special needs trust exists, and by law, that's been in place since 1993. Those proceeds won't count, and they can be used to provide value-added services and products to the homeowner. For example, the homeowner may need private duty aid. They may need additional therapies that Medicaid is limited in covering. They may want a private duty room instead of a semi-private, which is paid for by Medicaid. So those are just a few examples of how they can use the proceeds that are in the special needs trust. The second option, if we have a homeowner that is over age 65 and we're not allowed to use the special needs trust, then we can use what is called a pool trust. So it's a type of special needs trust that is already in existence. It's managed by a charitable organization, a 501c3, and multiple people around the state can pool their resources into the pool trust and have a separate account managed by the charity and get the same benefits. Medicaid knows the pool trust account was set up. They know the homeowner does not have the direct control or access, and as long those funds are used solely for the benefit of the homeowner during their lifetime, then the pool trust account does not count. So these are just a few of the very creative ways we can continue to help the homeowner qualify for Medicaid assistance. Now, I'm going to have Marty share with us the wonderful program that he instituted as our Broward County property appraiser, and tell us how as homeowners do we protect ourselves and our loved ones from fraud.
Oh, well, thank you so much, Stephanie. Can you all hear me pretty good? Excellent. Stephanie, can you hear me?
I can.
Oh, great. Excellent. Well, hello, everybody. And Stephanie, thank you so much again for having me on. Our Owner Alert program is exceptionally important. And I'll tell you why, and I'll tell you what it does, and I'll tell you why we created it. Unfortunately, South Florida is the title fraud capital of the world. What you have is you have criminals, and those criminals will go into the recording divisions for every single county, and they'll file fake deeds on people's properties. And then they'll take those deeds and they'll try to extort people for money or mortgage rent or even sell their property. They do it all the time. And the reason it's so easy for them to do is because the recording divisions for every single county have a ministerial duty. They have to accept whatever document is filed with them. So you have these criminals, they'll walk in, they'll file these fake deeds, and they'll do something nefarious with it. And so we wanted to give the people of Broward County the opportunity to fight the fraud before the fraud occurs. And so we actually came up with a great program. We developed it about a year ago. We spend no taxpayer dollars doing it, and it's free to the public, and it's called Owner Alert. And here's the way it works. If anybody goes to our website, which is web.bcpa.net, or our other website, which is bcpa.net, and you click on Owner Alert, you can sign up. And what you do is you type in your name, and then you type in your parcel ID number, which you can easily grab from our website. And then you also type in your email address. And if we have your email address on file, that's because we had it as when you filed for homestead, you are automatically verified. If we don't, we ask that you upload your Florida driver's license or Florida ID. If you don't have that, there are other ways to get verified as well by uploading, for example, a utility bill, just showing that you own the property. And then if anybody files any document, legitimate or not, on your property, you'll be notified instantaneously so you can fight the fraud before the fraud occurs. We've had about 180,000 Broward County property owners sign up so far, and it's my goal to get every Broward County property owner to sign up because it's there to protect their most important asset, which is their home. And something I also wanted to bring up, this is a really big crusade of mine. It's a crusade of mine because I see the people that these people try to pick on. They pick on seniors. They pick on low-income people. They pick on people who own property here but may not live here. They pick on anybody that they can pick on that they feel that they can get away with this the most. And so we've actually been working with law enforcement to build criminal cases against people who are doing this on a large scale. We've entered into an interlocal agreement with our Broward State Attorney, Harold Pryor, and we've helped them develop cases, and they're prosecuting people that are doing this. We're also about to enter into an interlocal agreement with the Broward Sheriff's Office to assist them, and we're working with all the police chiefs throughout Broward County in doing this as well. And let me give you some examples where we were very successful in putting people in jail for a long time. We actually worked with the U.S. Attorney's Office for the Southern District of New York, and we prosecuted 2 people who stole millions of dollars in property in Broward County and New York. They were found guilty. They're going to go to jail for a long time. An interesting fact about that is one of the people that did that actually ran for the state senate in Broward County. Fortunately, she lost that election. She's going to be serving her time in jail for stealing people's properties. We also worked with the U.S. Attorney's Office for the Southern District of Florida, and we actually built a criminal case against 2 wives that stole lots of properties here in Broward County. And let me tell you what they did, and this really illustrates how smart some of these people are. These are the type of people that if they did something legitimate, they'd probably be multimillionaires. Instead, they make their money by defrauding the public. You had one wife who worked for one of our hospital districts. You also had another wife who worked in the real estate industry. The wife who worked in the hospital district would find out when people would pass on. She would then take that information and she would give it to her wife in the real estate industry, who would find out if they had property here and if they had heirs here. And if they had property with no heirs, they would file fake deeds on those people's properties, and they would take those deeds and they would extort them for money. They'd mortgage their properties, they rent their properties, they sell their properties. They profited in the amount of millions of dollars. Fortunately, they were found guilty, and they're both about to go to jail for a long time. And even though they are a married couple, I'm very happy because they're going to be spending their time in prison in 2 different prisons. One other example I wanted to give you that kind of shows how smart these people are and how easy it is to steal somebody's home. There was a $2 million piece of property in Fort Lauderdale. And one day, the Homeowners Association president was just walking around talking to people. And he started talking to this guy. And he goes, you know what, I'm so excited. I'm actually buying this property. It is beautiful. I love it. I'm going to make it my forever home. I'm buying it for $2 million. It's going to be great. The Homeowner Association president walked away thinking, you know what, something is not right here. I don't think the person that actually owns this property really wants to sell this property. So he called me and he called our office. And we reached out to the actual owner of the property who lives in Canada. And the owner of the property in Canada basically said, I don't want to sell that property. I love that place. That's where I come in the winter. I'm not selling that at all. Something's going on. So we then contacted the real estate agent. The real estate agent said, oh, no, this is legitimate. I've been hired by a title company in Orlando. We contacted the title company in Orlando, and they said, oh, no, this is legitimate. We see the ownership documents that have been provided to us show that these people that are selling the property own the property. So we looked at it. They sent us the information they had, and it turned out that they were relying on 2 fake passports that these other people created, the fraudsters created. They basically put the name of the Canadians on the passports. They took their pictures and put it on these fake Canadian passports. And that's what the title company was using to say this was legitimate, and they were just about to send the $2 million to the fraudsters. Fortunately, we stopped that. I brought that up, and I wanted to tell you those stories because it shows how easy it is for these people to do terrible things to the people of our county that own property. So I hope everybody on this call signs up for Owner Alert. It is very important. And I also want to let everybody know I am committed to making this one of my #1 priorities in our office by cracking down on fraud, because I want every single fraudster that is thinking about doing this to know that they're not welcome in Broward County. And if they do it, we're going to work very hard to put them in jail for a long time because that's where they deserve to be. With that said, I just want to thank you so much, Stephanie, for having me on. I love being our Broward County property appraiser. It is such a fabulous job where you get to help so many people. So aside from Owner Alert, if anybody up here is wants us to ever look at the value of their property, because again, we determine the value of your property for tax purposes, or if there is any tax saving exemption you're currently not getting or your client's not getting, go to our website at bcpa.net, click on exemptions. If there's something you're not getting, call me, email me anytime. We want to make sure you get that. And also, if anybody ever up here ever has a legal question, maybe your client is thinking about selling their property, or maybe they're thinking about putting it in a trust, or maybe they're thinking about changing the deed. You can absolutely use our office as a resource. We'll let you know what happens to your property if you make those changes, and give you all kinds of information so you can make the best decision possible. With that said, Stephanie, thank you again for having me on. You're awesome. I think your presentation's been fabulous, and I appreciate you giving me the opportunity to say a few words today.
Thank you, Marty. Stay with us because people are going to have questions. So
Sure,
now we're going
absolutely.
to have Mila join us, and Mila is going to talk to us about different forms of real estate ownership.
Thank you so much, Stephanie. And thank you, Marty, for giving me the opportunity to speak as well. So one of the variety of ways people can own property can, like Stephanie said, can help you avoid going to probate. One of those is an interesting tool, and it's called an enhanced life estate deed, also known as a lady bird deed. Deeds are just the formal name for a recorded document that is used to transfer ownership of real estate. Many times, folks want to download, very much like Stephanie said, for the durable power of attorneys, want to download a form or go to Office Depot and find a form in order to transfer their real estate. They do not want to use the services of an attorney because lawyers cost money, but lawyers cost money for a good reason. They cost money because they have the legal knowledge and know-how to prepare this deed in the way that is consistent with Florida law. The law is specific. It has requirements for wording. It has requirements for legal descriptions. The deeds have to be signed and notarized in front of two witnesses and then recorded. What I see so often are folks that prepare their own deeds and they save a little bit of money on the front end. But in the back end, they end up costing themselves thousands and thousands of dollars because to undo a poorly drafted deed, sometimes you lose your exemptions because you didn't realize you weren't adding someone to the deed. You were fully transferring the property. So, like Marty said, I think it's always helpful if you're not sure. Always hire a lawyer and use our office as a resource. You can call and ask, well, if I change ownership and let's say do a ladybird deed to myself and to my children as the remainder interest holders, which means they automatically become the property owners once the life estate owner passes away. Does that affect my homestead exemption? We'll answer the questions for you, the fact that it would not. But again, it has to be prepared properly, recorded properly in order to make sure you're protecting yourself. So the enhanced life estate allows you to have ownership of the property for the duration of your life. And then upon your passing, it automatically transfers to those that you designated as the remainder interest holders. So it's to you for your life, with the remainder to, for example, many times it's your adult children. Now, if it's more than one child, it's important to denote how those kids are to own the property. And we'll talk about that next. We'll talk about joint tenants, the rights of survivorship. We'll also talk about tenants in common. Very, very important to denote how you want them to own the property, because if you leave that silent, the law defaults to tenants in common, and that's a percentage ownership. So let's say you have two adult children, you want to be the remainder interest holders, for example, from Mila for life to Skylar and Sydney, my children. Upon my passing, if I don't write how Skylar and Sydney are to own that property, the law presumes it's 50-50. So Another important way to own property is joint tenants with rights of survivorship. So that means however many joint tenants own the property, they each own overlapping 100% interest of the property. Many folks use this as an estate planning tool, again, with your adult children. So if you've owned your home for many years, you want to make sure you keep your homestead exemption. Maybe you're getting additional kinds of exemptions. You have adult children, they have their own homestead, whether it's in Florida or even if they live outside of Florida. You want to make sure, if in fact you don't want the property to go through probate, you prepare a deed, or most importantly, have a lawyer knowledgeable in this area of the law prepare a deed where you add those kids, those adult kids, to ownership, but all of you own it as joint tenants with rights of survivorship. So when one of the folks passes away, the other people who are joint tenants with rights of survivorship, that survivorship is the key term, continue to own the property and they each own 100%. Now, be careful. I know Stephanie has shared a story and Marty shared a story. I'm going to share a story with you of a gentleman who prepared such a deed in 2014. He came in, he had a wonderful son. He was so happy. He was transferring the property from him to him and his son. His son was going to help him take care of the property, absorb some of the financial burdens of that property, and everything was fantastic. A year later, the son got married, and the son and his bride wanted to move into that home as well because now the son owned that property just like dad did. Dad said, well, son, this is my property. I paid for it. I've been paying the mortgage for it. Yes, you're supposed to help me with some of the expenses, but my intent was never to gift the property to you and take me completely out of it. I intend to live here for the duration of my life. Well, things did not end very well. And the poor man coming back to my office probably every 6 months crying, saying, I need to get my son off of the property. I'm the one who added him. Why can't I remove him? And the problem is, once you sign on that dotted line, once your signature is witnessed and notarized and that deed is recorded, and you give someone ownership rights, just like you have, that person has the same ownership rights, just like you. And unless they agree to transfer their ownership rights back to you or to somebody else, you cannot force them to. So we all do things and think the best of our family and our friends and think our children will never fail us or change their minds. But as Stephanie said, and as Marty said, sometimes you have to be very cautious because when you make these kinds of serious decisions, sometimes you can't undo them. Now, then on slide 13, the next type of property ownership is called tenants by the entireties. So tenants by the entireties is very similar to joint tenants with rights of survivorship because if one of the tenants passes away, the other one already has a 100% interest on the property. But this designation is exclusive for married couples. The other one, joint tenants with rights of survivorship, don't have to be married. Tenants by the entireties, it is only for married couples. Now, I touched upon tenants in common a little bit earlier, and that is a percentage ownership of a property. So you can designate the percentage. It could be 90% for one person and 10% for the other. If there are multiple folks on the properties, many times they each own a third. What happens in these situations when one of the tenants passes away, that percentage interest does not transfer to the other two or the other tenant. It goes to that tenant's heirs. So it goes into their estate, which does need to be probated. Another important thing with tenants, if one of the tenants is homesteaded at the property, if the property is their permanent residence and they've applied for and received the homestead exemption from property taxes, not the homestead exemption Stephanie was talking about earlier. Florida law, the Florida Constitution actually has several homestead exemptions. the ones that our office administers is the homestead exemption from property taxes. So then, if you own only a percentage interest in your homestead, you're only going to be receiving benefit on the percentage you own. So that's also very, very important to make sure you know when you are determining how to best style the ownership of your home. Now, with respect to deed preparation, I know I started with this and I'm going to finish up with this as well. A smart person reads everything they prepare and goes to the professional to prepare what is necessary. For example, if you have a medical issue, you're going to see a doctor. Sometimes taking Tylenol for your headache doesn't work, or works and doesn't work. And at some point you say, I really need to go see that professional, that doctor. With lawyers, it's very similar. You need to see a professional to make sure you do not make mistakes, which you would know are mistakes because you're not the one skilled in the preparation of legal documents and what's required in Florida law in order to make sure whatever transfer you make is first in your best financial interest and second is done consistent with Florida. Marty had mentioned that we offer of so many tax saving exemptions. The best way to find them is to check out our website, bcpa.net. If you're moving from your current homesteaded property to another property anywhere in Florida, don't forget to save our homes, those portability savings. Those are important dollars that then you do not have to pay taxes on a Florida homestead. But I say Florida because it only works in the state of Florida. So thank you, Stephanie. Thank you, Marty, for giving me this opportunity.
Thank you, Mila. So in closing, we hope you walk away with the understanding that as many of the aging challenges that you're going to encounter, there are solutions. So the best approach is to stay calm, not panic, get the professional advice, like Mila said, and plan ahead, because by planning ahead, we all have more options available to us. We're going to avoid emergency situations that can cost more, and most of all, we preserve our own privacy. And don't forget that we talked about that as soon as our children become an adult at 18, it's important for them to have certain documents that we would, the power of attorney and the designation of healthcare surrogate. And please don't do it yourself. Don't go on the internet. Don't go to a stationery store. Do it right from the beginning. So at this point, I would like to open it up to questions that anybody has for either myself, Marty, Mila. Go ahead and feel free to unmute your microphone. It can be questions about exemptions, taxes, portability, different types of deeds. Okay, well, I'd like to thank everybody who joined us this evening, and especially Marty and Mila. Thank you so much for sharing what you do in the Broward County Property Appraiser's Office and how you're here to help all of our consumers in Broward County.
Oh,
Real
well,
quick,
thank you
this is
so
David Lieberman. No questions, just a thank you, and I know there's a need for follow-up. So really appreciate what I heard and saw tonight.
Oh, that was so
Thank you, David,
nice.
for joining.
Oh, definitely. That was so nice of you, David. And Stephanie, thank you so much for having me on. I was real excited about this, and I just appreciate you giving both Mila and myself the opportunity to talk with people how we can help our community. And so you're awesome. Have a wonderful day, and thank you so much, everybody.
Thank you, everybody. And thank you, Stephanie. Very, very informative presentation.